Hello, and you're very welcome to this session on accountability, helpful privacy program tips. My name is Martin McElroy, and I'm a Senior Data Protection Advisor within the Privacy, Security and Information Law Group at Fieldfisher, and I'm also Fieldfisher's Data Protection Officer. So this is the latest session in our Get Data Protection Fit series. As a brief recap, so far we've completed Module 1, which covers the fundamentals of data protection law. And Module 2A, which covered several aspects of putting data protection into practice. And we are now on the final session of Module 2B, still focusing on putting data protection into practice. And as mentioned, we are looking at accountability and helpful practical privacy program tips today. All our previous modules are available on our YouTube channel. Don't forget to like and subscribe as modules 3, 4 and 5 are coming up in the autumn with more to come in 2021. And so looking at learning outcomes for today, by the end of the session, you should be able to explain the accountability principle, why the accountability principle is important, and we'll be looking at a range of practical tips on building a culture of data protection accountability in an organization. The structure of today's session reflects the learning objectives on the previous slide. So we'll reflect on both the accountability principle and the importance of the accountability principle before looking at what accountability measures mean in practice, and then finally doing a deeper dive into some practical tips on how you can implement accountability within your organization. So let's start at the start and take some time to look at the accountability principle in a little more detail. So the accountability principle has been written into Article 5, Paragraph 2 of the GDPR, and it states that the controller shall be responsible for and be able to demonstrate compliance with Paragraph 1, the other data protection principles. And as a quick reminder, the principles outlined in Article 5, Paragraph 1 include making sure that the processing of personal data is lawful, fair and transparent. It also includes the principles of purpose limitation, data minimization, accuracy, storage limitation, and so on. So breaking it down further, when we look at the accountability principle, we note that there are two key aspects to it. So one, that data controllers are responsible for complying with the GDPR, and two, data controllers must be able to demonstrate compliance. Therefore, the GDPR has made it necessary for all data controllers to whom GDPR applies to consider what it actually means for a controller to be able to demonstrate their compliance. In other words, their accountability. So accountability means putting in place appropriate and effective internal data protection arrangements. It's important to have strong accountability measures in place for a number of reasons. Firstly, as we've seen in the previous slide, there's just no escaping the fact that it's a fundamental principle of the GDPR. But going beyond that, it also helps to develop trust, and it demonstrates an organization's respect for people's privacy. The ICO also believes it may provide competitive advantage for organizations. And certainly we have seen that a lot of organizations engaging vendors, suppliers, etc., have a high expectation that accountability type measures are in place. And this can be demonstrated in the form of detailed information security and data protection compliance questionnaires that organizations are now obliged to fill. Finally, good accountability measures can mitigate the effects of potential or actual enforcement action. For example, in the case of data breaches, it's no coincidence that data protection authorities look for evidence of strong accountability measures around data breach management. They're looking for examples of an incident management process, a breach register, security and data protection training for staff. All of these are accountability measures that can demonstrate compliance with Articles 32 and 33 of the GDPR for example. So what do accountability measures look like in practice? Well, you will almost certainly be using them all of the time, but you may never have actually tied back their use to the accountability principle. Accountability measures can include having things like data protection policies and procedures in place, having a data protection impact assessment process in place, and a number of DPIAs as well. It can be having up-to-date records of personal data processing. It can be having an incident management process, an incident management register, and so on. It can even include having a data protection officer in place. Indeed, even the role of the DPO can make an interesting accountability case study. Do you have a DPO in place? Do you need one? Some organizations took a decision prior to GDPR coming in May 2018 that they didn't need a DPO. Does that need to change now? Did you record the reason why the DPO was not appointed back in May 2018? Do you have a process to trigger the appointment of a DPO in the future? So having both this thought process and documenting the decisions, in this case, whether or not to have a DPO, these are all important accountability steps. Most data protection authorities have issued further guidance and checklists on what these accountability measures should look like, and I would encourage you to check your local data protection authority website, as they often have useful information on accountability measures. Here in the UK, the ICO has a dedicated accountability section on its website, and in fact, it launched a consultation on a proposed accountability toolkit at the end of 2019. The findings of this have been postponed due to the ongoing COVID-19 pandemic, but they should be available before the end of 2020. The ICO hope that the toolkit will act as a prompt for organisations to take responsibility for designing their own accountability framework, appropriate to the level of processing that takes place in the organisation and the particular circumstances of their organisation. So watch the space for further development on this. So how can your organisation demonstrate compliance with the accountability principle? And how do you build a culture of accountability within your organisation? Well, it can be difficult. Creating a culture of accountability around data protection is a challenge for some organisations. There is the often heard, we've done GDPR already attitude and mentality from boards who believe that all GDPR work was finished in 2018. 2 years down the line from the GDPR, a lot of the project teams involved in preparing for the implementation of the GDPR have been broken up. And as we probably all know, resourcing privacy professionals is an ongoing challenge. And business as usual tends to get in the way. So some DPOs and privacy teams are in constant firefighting mode, responding to sharp increases in maybe data subject rights requests or breaches or incidents. So it is problematic. The ICO says that accountability is not and should not be a box ticking exercise. Being responsible for compliance with the GDPR means that you need to be proactive and organised about your approach to data protection, while demonstrating your compliance means that you must be able to evidence the steps you take to comply. And there are those two words again: responsible for compliance, demonstrating compliance. And we will now go on to look at some of the practical ways you can create and build solid accountability measures within your organisation. No DPO is an island, and no DPO can impose a set of accountability measures across an organisation without the support and collaboration of others. Accountability is not the sole responsibility of the data protection officer or privacy teams. Everyone within an organisation at every level has both responsibility and accountability under the GDPR. DPOs and privacy teams need to identify, engage and interact with other stakeholders across organisations in order to deliver accountability measures and their privacy programs. A lot of organisations suffer from operational silos. So some DPOs and privacy teams are embedded within legal functions and often have little or no visibility of what is happening within IT, HR in other parts of the business. So while not directly comparable, the IGRM, or the Information Governance Reference Model, provides a useful point of reference to show how privacy teams are tied to the wider business and compliance structures. And actually, arguably, the data protection governance structure is wider than what's shown on the screen, moving beyond IT, legal and records to incorporate HR, finance, marketing, as well as the wider business. But the IGRM does show that privacy, security, legal, IT are all tied together in a single strand. So how to address operational silos? Well, we have a number of suggestions. You can map your stakeholders like you mapped your data pre-May 2018. So get to know your CISOs, your heads of HR, CIOs, heads of finance, marketing teams, etc. Take them for a coffee, and appreciate that this may need to be a virtual one at the moment, and get to know their priorities and challenges. Likewise, share yours. These are all important allies for data protection officers and privacy teams. And if not in place, seek to develop data protection champions throughout the various teams listed and meet regularly. Data protection champions groups can be a great way to cascade information and make people in the wider organization aware of accountability requirements, as well as other general data protection issues. And looking a little closer to home, DPOs and privacy teams should also have a regular cadence of meetings. This could be monthly, it could be quarterly, and these should be formally scheduled with recorded minutes, notes, and actions to demonstrate a record of decisions. Governance and stakeholder engagement is a key component of accountability. Training and awareness of data protection also plays a key part in demonstrating accountability. Training records are often used as an important metric for data protection officers, boards, and it's no surprise that information on the level of training received by staff involved in personal data breaches is one of the key preliminary questions by data protection regulators when notifying a personal data breach. So ask yourself, has your organization delivered data protection training since May 2018? Are your training materials up to date? Are they still relevant, or were they exclusively prepared for GDPR coming into place? And think more in terms of a training or awareness program. And this should be more than just generic classroom data protection training or onboarding training delivered to new joiners to an organization via a learning management system. Training should really focus on the how-to within your organization. How do you deal with data subject rights requests? How do you deal with a security incident? Where should people go to notify a security incident? Where should people go for information on engaging with vendors in order to meet Article 28 compliance? Training should be bespoke and appropriate to your organization. Awareness is important as well, and awareness via regular campaigns delivered via newsletters, emails, intranet campaigns are a critical part of the accountability program as well. Make use of existing events in the calendar, such as Data Privacy Day on the 20th of January, or by tying in privacy and data protection issues into the Cybersecurity Month program. And all of the above should be scheduled and documented into a formal plan by privacy professionals. And speaking of documenting, it's important to record all decisions and advice from DPOs and privacy professionals whenever they are made. There should be regular DPO privacy team reporting on a regular monthly, quarterly, annual cycle, whichever is applicable to you and your organization. And these should monitor ongoing compliance and highlights risks issues for management. Now, there are a number of dedicated privacy management products on the market that help with documenting compliance and putting accountability measures into practice. Some of these are well known, such as OneTrust, TrustArc, DP Organizer, Cytorus, etc. This list is not exhaustive, and there are other products available. But if resourcing is a challenge, then use anything that could be reasonably used to demonstrate a record. This could be Word, this could be a table in Word, it could be Excel. Use anything that could be reasonably used to demonstrate a record. Find a process that works for you and your organization. Create a central repository for all of these records and decision-making documents, and stick to it consistently. DPOs and privacy professionals should also look to leverage or utilize tools and processes that are often available throughout organizations. For example, there are a number of widely used risk management frameworks such as ISO 27001, NIST, and others such as Cyber Essentials here in the UK. Privacy professionals can utilize these to ensure the strategic and tactical delivery of goals around Articles 25 and 32 of the GDPR, for example. These frameworks were historically driven by information security concerns, but have recently been enhanced by specialized privacy-related accreditations in the guise of ISO 27701 and the NIST privacy frameworks. It's probably worth saying that these frameworks do not provide a silver bullet to fix all accountability issues, but they can facilitate governance structures, a regular cycle of policy updating, staff training, documenting and managing risks, all of which clearly aid the accountability agenda. Vendor vetting and supplier management is another commonly used process within organizations. And many organizations have well-established processes around the assessment of suppliers and vendors as data processors. Does your organization have an existing vendor vetting program, perhaps centered around information security? If so, again, this is often a quick win for privacy professionals, and appropriate data protection provisions could and should be added as a separate but linked stage gate in the procurement process and the due diligence of vendors. IT security teams also have well-established incident management processes that can also be leveraged by privacy professionals. And often these can be easily adapted so that there's, for example, an additional escalation point to the data protection officer to consider and review the incident. And earlier, we talked about dedicated privacy products such as OneTrust and TrustDark. However, look around your organization. New or specialist data protection technology may not always be required. So, for example, IT service desk management tools such as ServiceNow and others can be used to track incidents in the event of a data breach, or they can be used to capture the various stages of a response to a subject access request. Organizations often have document management systems, and these help ensure that your data protection policies are scheduled for regular updates, reviews on an annual or other regular basis. And quite often HR and training teams have access and availability to learning management systems. And these can help deliver standard sets of training materials to staff. So there's not always a need for DPOs and privacy professionals to go out and acquire new tools and processes. Quite often, if they look around the organization, there are plenty of available tools and processes to support that the DPO or the privacy professional can repurpose. So as a takeaway, there are a number of next steps that you could consider to help strengthen or create a pro data protection accountability culture within your organization. You could review your current governance structures and stakeholders and consider creating a data protection stakeholder map. Ensure that you have an adequate level of training and awareness for staff handling personal data within your organization. Document all decisions, planning, policies, processes, especially those that come from your data protection officer, your privacy lawyers, or managers. It's really important to have those decisions documented. And look around your organization. Understand and reuse tools, processes that could be used or reused for data protection purposes. And if in doubt about where you're at, consider undertaking a baseline accountability audit to assess your organization's maturity, and from there, to develop a plan to implement some of the measures I've described in today's session. Even the act of developing and documenting a plan to address any gaps will in itself be an accountability measure in its own right. And from there, hopefully other accountability measures will follow. Looking back at our learning outcomes, at the end of the session, you should now be able to explain the accountability principle, why the accountability principle is important, and explain a range of practical tips on building a culture of data protection accountability within an organization. And finally, I'd like to thank you all for joining this short overview of accountability, helpful privacy program tips today. My contact details are on the screen, and please do get in touch if you have any questions. And if you're interested in this topic, we will be running a more detailed webinar on accountability in September with details to follow. As mentioned, all our previous modules are available on our YouTube channel. Don't forget to like and subscribe, as modules 3, 4, and 5 are coming up in the autumn, with a lot more to come in 2021. Thank you and goodbye.